Hey class, welcome to week 9. I decided to switch this over to the spring image rather than the winter one because at least here in the DC area it certainly feels that spring came a couple months early. Okay, so this week we're going to talk about constitutional law, including issues of justice and fair play. So in this lecture we're going to talk about the US Constitution and how it applies to not just the federal government, but also to state and local governments. Specifically, we are going to examine the Bill of Rights and two important clauses we find there, the Due Process Clause and the Equal Protection Clause. In order to understand how we protect our constitutional rights, we're going to do a short review of our courts and how cases move through the court system. And then finally, we're going to discuss the concept of environmental justice, including the impact of government actions, constitutional issues related to environmental justice, and a look at one particular case study of environmental justice, that would be in Flint, Michigan, and some new strategies that advocates are using in these environmental justice lawsuits. Now, this is a class about hazards management and emergency response, so we will be discussing the unfolding COVID-19 pandemic, but not today. I did consider changing around our syllabus to address it now rather than in a few weeks, but I've decided to wait and see how our nation's actual response plays out. So we will address this starting in week 12. All right, I want to talk about the US Constitution because it is what creates the biggest limit on agency discretion and agency actions. And that's what we've been discussing throughout the semester because those are very important for both environmental law and all hazards management law. The Constitution is based, at least in spirit, on the Magna Carta, which was a charter of rights agreed to by King John of England in 1215. And the Magna Carta was designed to make peace between the king and a group of rebel barons. So it promised protection of things like church rights, protection for the barons from illegal imprisonment. It permitted access to swift justice, and it limited feudal payments to the Crown of England. Now, this was really focused on the ruling class. It was about barons and other nobles. But the Magna Carta influenced American colonists, and it was used as a model for the US Constitution. So as we've discussed, the Constitution's first 3 articles, they really embody this concept of separation of powers, and they do that by dividing the federal government into 3 co-equal branches: legislative branch in Article 1, executive branch in Article 2, and the judicial branch in Article 3. Articles 4 through 6 embody the concept of federalism because they set forth the rights and responsibilities of state governments in relation to the federal government. And together, the Constitution forms the supreme law of the land in the United States. Federal and state governments can grant people additional rights than those are provided in the Constitution, but they cannot reduce our constitutional rights. And I say people, not just citizens or Americans, because many aspects of the federal and state constitutions apply to all people who are physically present in the United States. They are not just for citizens. So our Constitution took effect in 1789. It has been amended 27 times since then. That includes the 18th Amendment, which established prohibition, and then about 15 years later, the 21st Amendment, which repealed the 18th Amendment and abolished prohibition. Now, the first 10 amendments to the Constitution are collectively known as the Bill of Rights, and they offer some specific protections for us as individuals by placing restrictions on the powers of the government. So the Constitution really kind of creates a contract between our federal government and us as the people of the United States. We agree to be governed by the federal government, so we give up some freedoms in order to be governed, but the federal government in return promises these rights and civil liberties. So it really does kind of form this contract. So I'm not sure how much experience everybody has with the Bill of Rights, so we're going to run through them now. And at the very least, this is going to be really useful for you if you play Jeopardy or Trivial Pursuit. So the Bill of Rights is the first 10 amendments to the U.S. Constitution. Originally, the Bill of Rights was only applicable to the federal government. However, we quickly realized that restricting the federal government from violating our civil rights doesn't really matter if the state government and local governments can do it, because we all have far more interactions with our local governments and our state governments than we do usually with the federal. That, of course, is different for those of us who work at or with the federal government, but just generally in the US, Americans are going to have more interactions with, say, local police than with the FBI. So the Supreme Court began incorporating the Bill of Rights against the states. So incorporation is just the legal process by which portions of the Bill of Rights get applied to the states. And this happens through a mechanism in the 14th Amendment. It's the Due Process Clause in the 14th Amendment that says, "No state shall make or enforce any law which shall deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of laws." So it was through that clause that the Supreme Court began incorporating the Bill of Rights against state governments and local governments. I'm going to run through and actually show you in blue which of the cases were incorporated by the Warren Court. So that was the Supreme Court with Chief Justice Earl Warren, who was a Republican appointee to the court, but it was through his opinions in his court that we got a lot of the rights that we currently take for granted today. So First Amendment, that is the amendment that deals with our freedom of religion, speech, the press, our ability to assemble and petition the government for redress. So Congress can make no law respecting the establishment of religion, so that guarantees that the government is not going to be tied up in religion. It's actually designed as much to protect churches and other religious establishments from government as vice versa. It also permits the free exercise of religion or the lack of that exercise. Freedom of speech, freedom of press, freedom of assembly, all sort of incorporated in the 1920s and 30s. Redress of grievances was finally incorporated by the Warren Court in 1963. Second Amendment is the right to bear arms. This was finally incorporated against the states pretty late in 2010. That was actually the latest constitutional provision to be incorporated against the states until incredibly recently, and we'll just talk about that in a moment. Third Amendment says that the government can't force us to quarter soldiers. This is actually not incorporated against the states by the Supreme Court, but if you happen to live in the federal Second Circuit, that's Connecticut, New York, and Vermont, it is incorporated against those states. But unsurprisingly, the Third Amendment has never been a primary basis of a Supreme Court decision. It's really not something that we tend to think about all that frequently, but was a much bigger deal back in our Revolutionary era. So the Fourth Amendment is where we get our rights against unreasonable search and seizure. So this requires that the police get a warrant upon probable cause that has to describe the place they're going to search and the person or the items they're going to seize. And then it also just generally permits us as Americans to be free from an unreasonable search and seizure. And those rights were incorporated by the Warren Court. Fifth Amendment, a lot of times we think of it just as double jeopardy, or we think, I'm going to plead the fifth so that I don't incriminate myself. It also, though, contains a due process clause. So the Fifth Amendment gives us the right to have an indictment by a grand jury. This part is not incorporated against the states, but it doesn't really matter because most state constitutions grant that right as well to their citizens. It does protect us from double jeopardy. The government can't come after us twice for the same conduct. Now, when I say the government, I mean a single level of the government. If you do something that violates both a state and federal law, then the state and federal governments can come after you. That's not double jeopardy. But if you've made it all the way through a trial and you're found that you're not guilty, the government doesn't get a second bite at that apple. We've also got the protection against self-incrimination, which is why you do not have to take the stand and testify against yourself. And there is also the just compensation for taking of private property. We tend to think of this as eminent domain. If the State Highway Administration is going to seize a portion of your front yard because it wants to widen the roads, it's the Fifth Amendment that requires that they actually compensate you properly. So the Sixth Amendment contains all of our various rights regarding trials. So that's the right to a speedy trial, the right to a public trial, the right to have an impartial jury, the right to know what we're accused of, the right to confront witnesses against us, the right to subpoenas so that we can compel witnesses to testify, and then, of course, the right to assistance of counsel. The Seventh Amendment is the one that everybody forgets, and this was actually one of the bizarre times when the framers of the Constitution didn't look that far into the future because they actually put down a monetary amount. So the Seventh Amendment basically says when you're suing somebody in civil court, this isn't for criminal issues, and you're owed more than $20, then you get to have a trial by jury. That obviously is not the case. It has not been incorporated against the states. It would really muck up the docket for our civil courts because $20 is just not that much anymore. The Eighth Amendment prohibits both cruel and unusual punishment as well as excessive fines and bail. Historically, there's been a lot of litigation, a lot of court opinions about cruel and unusual punishment, but not so much on the excessive fine portion of the Eighth Amendment. And this has been a huge issue for civil asset forfeiture, which is a process by which law enforcement officers can take assets from people who are suspected of being involved in a crime or criminal activity, even if it's just tangentially related. And the police can take assets from people without necessarily charging the owners with any type of wrongdoing. So if you see your local police officers driving around in really fancy cars, there is a good chance that those cars were seized from suspected drug smugglers during drug busts. Now, there are good reasons for civil asset forfeitures. It's a really effective way of fighting organized crime because you can't get all the people, but if you seize enough money and assets, it makes it harder for crime rings to operate. But there's been a lot of debate about whether these types of seizures constitute excessive fines against individuals. And this is particularly in light of some really egregious uses of civil asset forfeiture to take housing and vehicles away from people who did nothing themselves, but who had family members who police suspect of being involved in criminal activity. So there have been stories about, grandmothers losing their homes because their grandkids smoked a joint in the front yard. So civil asset forfeiture, there aren't a lot of good rules that really constrain law enforcement action related to this, and it can be really difficult to get your property back after it has been forfeited. Usually, people can only recover by paying for an attorney to go to court on their behalf. But even then, you get an attorney, you're probably still only going to get a partial recovery of your money and property. And what this means is that poor people are far more likely to have their property seized and never returned. And then they, of course, suffer a greater negative impact from the loss of their property because it is hard if you don't have money to simply go out and buy new stuff. So finally, in 2018, this prohibition on excessive fines was incorporated against the states. So states can no longer use civil asset forfeiture or fine you in a way that undermines your constitutional rights. Unlike this prohibition on excessive fines, the Supreme Court incorporated the protection against cruel and unusual punishment against the states back in 1962. Now, the court has been clear that the Eighth Amendment does not require comfortable prisons, but it does require prisons be humane. So in one of the most recent Eighth Amendment cases, Brown v. Plata, the Supreme Court specifically reminded the state of California that prisoners, although they are in prison, they still retain the right to be treated with dignity. So prisoners are removed from society as their punishment, they do not go to prison to be further punished or mistreated. And the Brown case focused on California's prisons because they had, for over a decade, operated at about 200% of their design capacity. And that resulted in some pretty horrific and unhygienic conditions. And it also resulted in a preventable death, about 1 every 5 to 6 days in the California prison system. The 9th and 10th Amendments deal with unenumerated powers and rights. So basically, the Constitution specifically, expressly grants us some rights. But they wanted to make sure, the framers, they wanted to make sure that that wouldn't be used to sort of say, hey, that's the inclusive list and you don't get any other rights. So specifically, the 9th Amendment protects rights that are not mentioned in the Constitution. Just because they're not mentioned in the Constitution does not mean that they don't exist. And the 10th Amendment says that powers that are not delegated to the federal government are reserved to the state governments and to the people. And that's when we had talked about hierarchical federalism versus more of a collaborative federalism, when the federal government starts to deal in issues that the Constitution doesn't allow it to deal in. That's when it starts to trample states' rights. Okay, so why did we just run through the Bill of Rights? Well, federal agencies and all of their employees are bound by the Bill of Rights, and state agencies and their employees are bound by the provisions of the Bill of Rights that have been incorporated against the states, which is really almost all of the important ones. Additionally, the due process clauses in the 5th and 14th Amendments, they require that the government treats people with some minimum standard of fairness before depriving them of their life, their liberty, or their property. And the Equal Protection Clause requires that the government treat people equally. So agency regulations can be invalidated if they violate the Equal Protection Clause, and even if the regulation itself is valid on its face, meaning it can be applied in a non-discriminatory fashion, the way an agency enforces a regulation can violate the Equal Protection Clause. As we'll discuss a little bit later, if the agency is enforcing clean air and clean water for rich gated communities, but failing to enforce them for the inner city or perhaps for rural communities, that violates the Equal Protection Clause. So due process. It's so nice we've got it twice. Both the 5th and 14th Amendments contain a due process clause. They are pretty similar. States can't deprive us of life, liberty, or property without the due process of law. And due process is literally the process that is due to an individual before the government deprives that individual of life, liberty, property, or some other fundamental right. And due process is basically a way of saying, look, some rights are so important and they're so fundamental that to take them away, if the government tries to take them away, there's got to be a strict standard of reviewing that, and there's got to be a really good explanation, if we're even going to allow the government to take it away at all. So fundamental rights, these are rights that require due process before the government can infringe on them. These are rights that we consider to be essential to freedom. They might be given to people by natural law, so sort of the entire all of human rights, when we discuss human rights, those are given by natural law. These rights also can be determined by reviewing historical foundations, such as the Magna Carta and the U.S. Constitution. They can also be determined by courts based on what we call our evolving standards of decency. So as we, as people, and as a society evolve morally, politically, technologically, all of that, we start to realize, oh, hey, we're actually infringing on some group of people because we really hadn't considered them before. But now our standards of decency have evolved. And so we're going to recognize them as full humans who should have all of the rights that all other Americans have. Okay, so these rights include everything that's in the Constitution and its amendments. So that includes the right to equal protection. And then a bunch of stuff that's not in the Constitution or its amendments, like your general right to privacy, although that is sort of evaporating in today's world. which we've not really had a robust social discussion about, which is unfortunate. The right to move about the country and usually around the world. So the U.S. government very rarely restricts us from going anywhere. It might issue warnings that places are unsafe, but it's pretty rare that you can't go somewhere on your own if you'd like to travel there. We have a right to enter into contracts with each other. We have a right to marry regardless of race and now regardless of gender. We have a right to procreate or not. We've got a right to own property, and we also all have the right to access the court system. So those are our rights. We also have protected interests. And who says that money can't buy happiness? Because the Declaration of Independence, which is a fairly lofty and aspirational document, that references the right to life, liberty, and the pursuit of happiness. But you'll notice that the Constitution, which, although also lofty and aspirational, is a much more formal framework of rights, it substitutes property for pursuit of happiness. So the framers of the Constitution certainly thought that property was part of happiness. And in part that's because they were rebelling against the monarchy, and in the monarchy, holding property was of paramount importance. So our protected interests are life, liberty, and property. Life is usually not an issue for agencies, although it'll be interesting to see if it does start to become one with climate change and a variety of man-made and natural disasters. But usually the only agencies that have to worry about infringing upon your life are law enforcement and correctional agencies. Also sometimes termination of welfare and termination of gas or electric service if it's extremely cold or extremely hot. Liberty also more for agencies that are involved in corrections and probation, law enforcement, but also immigration, as has been all over the news. In addition to not being locked up without due process, you also have liberty interests in your reputation. So agencies have to consider due process before making any type of public accusation that could damage somebody's reputation or be humiliating. This is also a huge concern in academic suspensions. So a lot of times this comes up not because the government feels like trash talking somebody, but because there might be a suspension or termination, and the government, if they have suspended or fired their employee, has to be really careful about what they say about it. And then we've got our protected interests of property, both tangible and intangible. So, tangible are the things that you can touch, your car, your house. Then you've got intangible, like intellectual property. Okay, so there are two types of due process, procedural and substantive. Procedural due process is all about, the minimum number of steps that the government's got to take before depriving somebody of life, liberty, or their property. So questions of procedural due process always involve a situation where somebody had something and then the government took that away. And we look to see, was there a process in place to protect that person from government error or from some type of government overreach? So as we learned when we discussed agency adjudications, if an individual is being deprived of a right or an entitlement, then they have to have some form of notice and hearing. And so procedural due process looks to see, how much notice is due, what kind of hearing do you have to have, and that really depends on what type of government action is taking place and also what right is being infringed. So the greater the right, the more due process that is required. And courts tend to balance the interest of the individual in retaining his property, the injury that is threatened by government action, the risk of an error, if you don't have enough procedures in place, the value of any additional procedures, as well as the administrative burden and the cost burden of having additional procedures, and then the interest of the government in effective adjudication. So that's procedural due process. What's the process do? Substantive due process is different. That's really an examination of the individual interest at stake and whether the government is unconstitutionally infringing upon that interest. So for procedural due process, the Administrative Procedure Act actually sets forth certain protections. So if your rights are affected by the government, you have a right to know why the government's taking action. You've got a right to bring an attorney to an agency hearing, if the purpose of the hearing is to find facts or discuss complex issues of law. That's not something that a layperson should have to go through on their own. And you've got a right to present your arguments, including presenting evidence. In terms of what sort of hearing, and then when and where it should take place, the APA, as to where, the APA permits agencies to hold hearings in DC, but they also tend to hold hearings at their regional and local offices. And if an agency requires that you travel to Washington, D.C. for a hearing, it's possible that the Due Process Clause of the Constitution will kick in and require that that hearing is held in a location that is more convenient for the parties who are affected by it. As to the type of hearing, everything's got to be fair, of course, but you only need that formal trial type hearing if there's a factual dispute or if the statute requires it. The bigger question is when hearings should take place. Do we have these before somebody's deprived of a right or an interest, or after the deprivation has already occurred? And so we talk about these as pre-deprivation and post-deprivation hearings. And to determine which hearing is necessary, agencies and also courts reviewing agency decisions, they're going to consider whether an individual will suffer additional harm if that person does not get a pre-deprivation hearing. They're again going to look at the value of requiring sort of additional procedure via a pre-deprivation hearing, and also the costs and burdens of that. The likelihood of error if there's no pre-deprivation hearing, and then the public interest in selecting one or the other. Now, pre-deprivation hearings, they don't have to be full hearings. But if they're not required, agencies still do have to take some action before they can deprive an individual of a right or interest. And generally that means like a brief and informal discussion. Basically the agency wants to see, if its charges against you are likely true or not. Now, if there is no pre-deprivation hearing, there's got to be a post-deprivation hearing. And that has to be pretty thorough, much more thorough than a pre-deprivation hearing. Additionally, the post-deprivation hearings got to occur close in time to the deprivation. So if you're fired, you need to have a hearing on that very shortly after you're fired. It can't be a year later. Additionally, actually, if you get fired or if you get expelled from a public school, that actually does require a full pre-deprivation hearing. Suspension, that requires an informal pre-deprivation hearing. There's also not a need for a pre-deprivation hearing if there is another form of hearing that took place. And usually that means you're in trouble with an agency and you're also in trouble with federal law enforcement because there's been a criminal trial that's taken place, and because of that criminal trial, the agency doesn't also have to give you a little mini trial. All right, so that's due process, and now we're going to have a look at equal protection, which is equally important. So the Equal Protection Clause is found in the 14th Amendment. That's the same amendment that the Supreme Court uses to incorporate the Bill of Rights against the states. And it's got several clauses, Privileges and Immunities Clause, it has its own Due Process Clause, but then it says that the government cannot deny the equal protection of laws. The Equal Protection Clause is also implicit in the Fifth Amendment Due Process Clause. You'll see that the due process language is almost identical. So the Equal Protection Clause is concerned with laws, regulations, and actions that classify and treat people differently. But it's important to understand that most classifications do not violate the Equal Protection Clause. We classify people all the time, by height, alphabetically by name, by age, so that you can drink alcohol or get senior discounts. Are you married or divorced? Do you watch The Bachelor? Are you a Ravens fan versus a Broncos fan? All of that. Those are all classifications, and they don't violate the Equal Protection Clause. Classifications that do violate the Equal Protection Clause are known as suspect classifications. And this is the classification of groups in such a way that indicates that the group is being subject to discrimination. So what this means in practice is that to affect a suspect class or to involve a suspect classification, a law must target what we call a discrete or insular minority. That minority must possess an immutable trait, such as skin color. Also, that minority has historically faced discrimination, and the members of that minority must be powerless to protect themselves via the political process. Now, two of these items are a little bit murky today. The first would be an immutable trait. That's fairly obvious when it comes to skin color. I think a lot of people realize that it's also now obvious when it comes to sexual orientation. Obviously, it's pretty obvious when it comes to gender, at least as we traditionally think about it. But it's not so obvious when it comes to religion. So classifications based on religion are suspect classifications, but religion itself is not necessarily an immutable trait. The other part, it's this last prong about protection via the political process that is especially murky today. This came up quite a bit during the debates over marriage equality. And that's because in our current society, a lot of gay people, particularly those in the middle and upper classes, are certainly able to influence politics through special interest in lobbying groups like Human Rights Campaign, through electing candidates who themselves are gay. Likewise, Black Americans today have a much easier time at the polls and in the courts and in electing Black politicians to represent them than at previous times in our history. But the fact that things have improved recently really does not outweigh centuries of discrimination that have entrenched these systematic inequalities. And while minority groups are indeed equal under the law, realistically, it doesn't always feel that way, particularly if you are a member of a minority group. So some examples of suspect classification, like those based on race and religion, these are immediately suspect all the time. Classifications based on ethnicity or nationality, they are also suspect, but only outside of the immigration and national security fields. So immigration law, national security law, those can make distinctions based on your ethnicity and your national origin. There are also classifications that are not suspect themselves, but they burden a fundamental right. And when that happens, these classifications also violate equal protection. As an example, there were states that had laws that required divorced people with kids, that's a non-suspect classification, to get court approval before they got remarried. But marriage is a fundamental right, and by making it harder for divorced people with kids to remarry, these laws violated the equal protection required by the Constitution. Here I've just got the equal protection pyramid, and we're going to talk about strict scrutiny and intermediate scrutiny and rational basis in just a moment. And when we do, feel free to come back to this slide, because you can see that, in the pyramid, suspect classifications are sort of a much smaller group than the everybody else down there at the bottom. There's also a concern about covert discrimination, which is very hard to prove. And this is when a law looks legitimate, but it's actually discriminatory. The biggest example of this over the years has been the U.S. sentencing guidelines that impose much harsher sentences for crack than for regular cocaine. They are two forms of the exact same drug, but African Americans were usually arrested for crack, and white businessmen were usually arrested for cocaine. So, that is actually a discriminatory law, the way that it was implemented. Additionally, the law can be legitimate, but an agency might administer it in a discriminatory fashion. For example, in Philadelphia, there was a swim club that denied access to a group of African American students, citing possible overcrowding. But then a bus full of white students pulls up and they were allowed in. So possible overcrowding at a pool is definitely, that's a legitimate interest. That can be a safety hazard. But you've got to apply it equally. It doesn't really matter the color of swimmers. So the disparate impact itself hasn't been held as sufficient. The courts basically say, look, you've got to prove that the law's purpose was discriminatory, not that it's just having a disparate impact. Now, we'll see disparate impact in environmental law and environmental justice because the majority of trash dumps, water treatment facilities, waste management facilities, things like that, they tend to cluster in poor and minority locations, thus having a disparate impact on poor and minority Americans. We're going to talk more about this in just a little bit. Okay, I also wanted to just briefly highlight again the courts because they are the ones that enforce our constitutional rights. So at the federal level, we've got 94 federal district courts. These are divided amongst 11 regional circuits, plus we also have the DC Circuit and the Court of Appeals for the Federal Circuit. So we actually have 13 total circuits. The Court of Appeals for the Federal Circuit is for specialized cases. Most importantly for us, it's the one that hears appeals from agency decisions. Now, at both state and federal levels, cases start at the bottom and work their way up. So they start in the trial court. Either the plaintiff sues the defendant or a state brings criminal charges against the defendant. The diagram that I've got here, it kind of shows how cases rise to the top of the court hierarchy. They also change names depending on if you're in federal court or state court. So I've explained that here just because sometimes it can get a little confusing if you're engaged in legal research and you notice that the names of your cases are switching. It's just a matter of appellate procedure. So federal trial courts, we call them our district courts. And that's usually the case in the states as well, but just be aware that names can vary. The party that loses at the trial level in a civil case can appeal to the intermediate appellate court. In a criminal case, the defendant is the only one who can appeal. If the trial court finds the defendant not guilty, the prosecutor cannot appeal that decision. But in civil court, you lose, you appeal up to the Court of Appeals, sometimes called an intermediate appellate court. Then, if you lose at the appellate level, you can appeal to the Supreme Court, either in your state, or if you're in federal court, you can appeal to the U.S. Supreme Court. If you have lost in your state Supreme Court, you can also appeal to the U.S. Supreme Court. However, the U.S. Supreme Court does not have to hear your appeal. The Supreme Court has a lot of discretion in which cases it takes, and it takes very few cases. One thing to keep in mind is, again, names. The highest state courts are usually called Supreme Courts. So there's like the Colorado Supreme Court. But in Maryland, the highest court in the state is called the Court of Appeals, which is nice and confusing because we also have intermediate courts of appeals. But so just be aware, again, names vary. New York is by far the strangest in terms of its state court names. So, you appeal. What can happen? The appellate court, be it your intermediate court of appeals or Supreme Court, it can affirm the decision of the lower court, basically says, yep, we agree. Usually the higher court will explain why it agrees with the lower court. It can reverse the decision of a lower court, basically overturn them. It can modify the decision of a lower court. So the higher court might agree with the overall outcome of the case, but it might have different reasons, and it might have slightly different outcomes. The higher court can also remand the case back to the lower court and basically say, nice try, we don't agree, try again. So if a case contains multiple issues, there can be multiple outcomes in the same case. So that's just important to keep in mind. Part of the case might be reversed and remanded, part of it might be affirmed or upheld. Right, so what do courts examine? Well, when they're looking at cases at the appellate level, they're obviously looking at the facts of the case and the evidence, what was introduced at the district court, at the trial court. Appellate courts also look at the terms of the statute, regulations, or constitutional provisions as they're written. So basically taking the words at face value. But they will also look to the intent of Congress, agencies, or the framers of the Constitution in writing those terms. And this allows the legal field to have a vigorous debate over which is better, but courts generally take a look at all of that. They will also make sure that there's compliance with federal and state due process clauses and equal protection clauses, and then just general compliance with other laws. Now, the way that they determine this when they're taking a look is that courts use 3 different standards of review: rational basis, intermediate scrutiny, and strict scrutiny. The rational basis test is most commonly applied, and strict scrutiny is least commonly applied. It's really reserved for reviewing laws that infringe on fundamental rights or that create suspect classifications. So the rational basis test is going to apply to any situation where there are no fundamental rights or suspect classifications at issue. And if a court reviews a law or regulation under the rational basis test, it is probably going to survive because it's the easiest test to apply. Now, interestingly, during the recent same-sex marriage equality debates, a lot of justices, prior justices, judges, and legal experts were actually saying that discriminating, marriage inequality, so discriminating against people because they want to marry somebody of their own sex, actually fails even the rational basis test. And that's pretty fascinating because rational basis is usually, the government's going to win. There's intermediate scrutiny. This applies to quasi-fundamental rights. Primarily, it's going to apply to time, place, and manner restrictions on speech. So the First Amendment grants us the freedom of speech, but governments can apply some restrictions on speech or assembly. That's why you've got to go ahead and, get a permit to hold your protest. This also comes up a lot in what we amusingly refer to as erogenous zoning cases, which generally require adult bookstores to be close together in a city. So that's a time, place, and manner restriction. You can only sell your porn at a certain time and in a certain place and, in a certain manner. If restricting time, place, and manner means that the speech cannot take place at all, then that law is going to fail intermediate scrutiny. This also applies to quasi-suspect classifications like gender and illegitimacy. And it applies to the regulation of commercial speech. You can go look up Bad Frog Brewing Company. Its logo is a frog that is flipping you the bird. And there was actually a case on, regulating commercial speech. Was it okay to allow the brewery to keep that as a logo? So that's intermediate scrutiny, but honestly, you don't have to really worry about that because most cases are decided on a rational basis test, and then the handful of really important ones that get a lot of public attention are strict scrutiny. And for strict scrutiny, the law that is infringing on your right has got to be narrowly tailored, it's got to further a compelling government interest, and it's got to be the least restrictive means. So crucial compelling interest is usually something like national security. Most government laws that infringe on fundamental rights that are reviewed under strict scrutiny are deemed invalid, so the courts invalidate those laws. All right, so how do courts decide which test to use? Well, they go ahead and look and see, Does this case involve a fundamental right or a suspect classification? And if it does, then the court is going to review the government action and the law at issue with strict scrutiny. So again, fundamental rights, they always require that highest standard of review. The government's got to prove a compelling state interest. It's got to prove that the law is narrowly tailored. So basically, the government's got to have a really, really, really excellent reason for infringing on your rights, and it's got to infringe on them the least possible amount. Now I want to turn to environmental justice, which actually can be classified as a constitutional issue. So environmental justice has several meanings. It's a social movement that's focused on the fair distribution of environmental benefits and burdens. It is a social science that really looks at how environmental laws are implemented, environmental policy and planning. Are you sustainably developing? And what's the interplay between politics, economy, and social factors? The EPA actually has a very specific definition of environmental justice. And again, it is about fair treatment and meaningful involvement of all people, regardless of race, color, national origin, blah, blah, blah. And the EPA says when everybody is enjoying the same degree of protection from hazards and the same degree of access to the decision-making process to have a healthy environment, that is when we have achieved environmental justice. Now, as you may have guessed, we have quite a long way to go. Environmental justice, this is the Environmental Justice Atlas, which is a really neat resource that I suggest. It's ejatlas.org. It's definitely interesting to play around. Environmental justice impacts people worldwide. The water and sanitation crisis is much worse in the developing world than it is in the developed world. And we're going to talk more about global environmental justice later in the semester. But for right now, we've only got time for like a real high-level review of environmental justice in the US. I will make a pitch if you happen to be interested in a global perspective on sanitation. I really like the book The Big Necessity, The Unmentionable World of Human Waste and Why It Matters by Rose George. I am not being paid by Rose George, but I read the book pretty recently and it was very eye-opening. Okay, but back to the US. The Environmental Justice Atlas lists 99 current, what it calls environmental conflicts in the US. And if you kind of look at the fact that environmental justice is concerned with the fact that a lot of waste management and high pollution sites tend to be located in poor and or minority-dominated areas. So that's part of what this atlas is capturing. Studies have shown that a disproportionate quantity of minority communities actually host landfills, incinerators, and other potentially toxic facilities. So these are issues of injustice that really affect the poor and minorities. Just a couple of examples. African Americans are the majority of residents in the region of Louisiana known as Cancer Alley. That's a stretch of the Mississippi River between Baton Rouge and New Orleans. And it's home to 125 companies, and it produces 25% of the petrochemical products that are manufactured in the U.S. And the U.S. Commission on Civil Rights has basically concluded that the African American community has been disproportionately affected by Cancer Alley because of the way that the state of Louisiana and localities in Louisiana use their permit systems for hazardous facilities. Additionally, because African Americans in this part of the country have fairly low socioeconomic status, they've got limited political influence, and thus they can't escape the inappropriate permitting processes that are disproportionately impacting them and subjecting them to harmful chemicals. It's not surprising to note that indigenous groups are often the victims of environmental injustice. Native Americans have suffered tons of these abuses, particularly relating to mining in the US and the West, especially. There's been a lot of like uranium mining on Navajo land. And basically, the mining has not only depleted the water supply, but it's contaminated what was left of the water supply. So certainly Native Americans have a disproportionate impact and suffer a lot of environmental injustice, as do Latinos, who make up sort of the remaining part of that trifecta of groups that are most adversely impacted by these types of issues. So a common example of environmental injustice amongst Latinos would be exposure to pesticides. This is like farm worker problems. So back in the 70s, after the US outlawed DDT, farms began using more toxic pesticides that just weren't DDT. And a lot of our farm workers are actually illegal or undocumented immigrants who come over just for the season and then go back home. Because, though, a large number of them are undocumented, they've got a real political disadvantage. They can't protest against the fact that they're being exposed to all of these pesticides, and they can't benefit from the protection of federal laws that would normally operate to protect them from this type of exposure. So we've got the U.S. Commission on Civil Rights saying that we have environmental injustice in the country. So back in 1994, President Bill Clinton signed Executive Order 12,898. It's called Federal Actions to Address Environmental Justice in Minority Populations and Low-Income Populations. And basically this executive order says, federal agencies, your missions have to include achieving environmental justice. So agencies have to identify programs, policies, and activities that might create these sort of adverse health and environmental effects that disproportionately impact minorities and low-income populations. And agencies have to develop strategies that identify and mitigate these effects. So they've got to promote enforcement of all health and environmental statutes. That's in areas especially where they're minority and low-income populations who cannot advocate for themselves politically. Agencies are supposed to ensure greater public participation in decision-making, particularly the decision-making that impacts communities and their access to clean air and clean water. Agencies are also supposed to improve their research and data collection and identify patterns of how we're using our natural resources to make sure that minority and low-income communities do get their fair share. Now, note that the executive order is not actually a source of authority in and of itself. What the executive order does is it requires agencies to go ahead and create the legal source of authority by promulgating regulations. So we're going to take a look at some government action other than presidential action that tries to get us to a point of environmental justice in the U.S. So USDA, keep in mind that the USDA is the federal agency that's got the biggest impact really on the everyday lives of Americans. This is especially true in rural America, where the USDA provides technical assistance and funding to individuals, organizations, and local and state governments. So the USDA is out there building health clinics, providing free meals to kids who live near or below the poverty line. It's even responsible for drinking water in rural areas. So there are areas of the country that are so rural that they would not have access to drinking water were it not for the USDA. So the USDA jumped on the executive order and it created this regulation, DR 5600-002, and that's what implements the executive order. Basically, the USDA regulation, you can read it right there, but it underscores civil rights, public access, and environmental laws. And a lot of these we've already discussed: Clean Air Act, Clean Water Act, FOIA, Government in the Sunshine Act, Emergency Planning and Community Right to Know Act, things like that. It also states that environmental justice issues arise where conduct or action might involve a disproportionately high and adverse environmental or human health effect on a low income or a minority population. So the USDA is out there admitting that there is environmental injustice. It also engages in mitigating these injustices through its environmental justice strategic plan, and it's got very specific tribal and rural outreach programs like the ones I just mentioned for, getting drinking water to places. So the USDA is really actively involved in a lot of outreach. And it has a huge impact on our society, which is why if you pay attention to the news, I think we actually need to be having more of a discussion about what the Trump administration is doing to the USDA, because that's really going to have a deleterious impact on the whole nation, but particularly on our rural areas. Okay, and then there's the EPA. So like all federal agencies, the EPA's got an environmental justice plan. It also has an Office of Environmental Justice, which oversees the implementation of its plan. The EPA recently, in 2017, it actually issued a progress report on its environmental justice efforts. And it really did actually note some tangible improvements for America's minority, low-income, and indigenous communities. So for instance, fine particle air pollution, now 92% of low-income people are living in areas that meet the air quality standards, and that's up from 43%, so that's a big jump. Small community drinking water systems, now we're down to 0.5% that have repeated health-based violations, meaning they're contaminated by certain specific contaminants. So that's down. It was 1.2% 2 years ago, but actually, they've reduced it even more. Same with tribal drinking water systems. There were 92 of these that were out of compliance. Now there's 65. So the EPA, if you want to read their progress report for environmental justice, it gets into a lot of detail. The EPA also has a document on environmental justice legal tools that's actually put together by their Office of General Counsel. And that document identifies the statutes and regulations that will protect public health or welfare, protect the environment. It also covers some of the non-regulatory programs where EPA can actually use its discretion to advance concepts of environmental justice. The EPA actually has an MOU on environmental justice with the Department of Interior, basically a partnership. And probably most importantly moving forward, the EPA recognizes that disparate impact is a problem. So if you've got a law that is valid on its face, but is disproportionately impacting minorities or poor areas of the nation, the EPA regs, they prohibit recipients of EPA funds from using any type of method or criteria that have the effect of discriminating. So it's not that the intent has to be discriminatory, just the effect of discrimination is sufficient for it to violate the EPA regulation. And you'll see in a moment that's quite a big deal. So the problem that I noticed that I think won't be surprising to anybody, as I was going through all these various environmental justice strategic plans and progress reports from agencies, a lot of these documents are full of good intentions, but they do not provide any specific legal commitments or resource commitments that are actually going to achieve environmental justice. So there's no teeth in a lot of these. However, it is possible that the U.S. Department of Justice can provide those teeth. So the U.S. Department of Justice, it actually has the authority to bring suits against law enforcement agencies that are engaged in a pattern or practice of unconstitutional conduct, which we've certainly seen quite a lot in the past few years with a lot of people of color being shot by police or detained against their will for reasons that were really just based on skin color. There was a really landmark settlement in Missoula, Montana, and that's landmark because the Department of Justice was actually looking at patterns of biased under-enforcement. So in this case, state and local law enforcement agencies, they're now on notice from the federal DOJ that if they are under enforcing or not enforcing laws, and they're doing this in a discriminatory fashion, that violates the Equal Protection Clause. So the question is, can this be applied to environmental justice cases as well as specific civil rights cases in law enforcement agencies? And we'll pick up on this in just a minute. Okay, so we looked at what the president did with an executive order. We've looked at a couple of executive branch agencies and what they've done. Congress, of course, also can address environmental justice. It's actually taken a lot of actions to confront it, although at the time, no one really thought of it that way. So there were obvious statutes like the Clean Water Act, Clean Air Act. There's also the National Environmental Policy Act, NEPA. So those are obvious that they can be used for environmental issues, including possibly environmental justice. There are also two Civil Rights Acts and the Alien Tort Claims Act. So the Civil Rights Act of 1964, you'll hear about it a lot as Title VI, and Section 601 prohibits any government agency that receives federal funding from discriminating on the basis of race, color, or national origin. Now, any government agency receiving federal funding, that means that this applies to state and local agencies. So Section 601, you can't discriminate. Section 602 requires agencies to create regulations to carry out this policy of not discriminating. So federal funds have to be used in a fair and equitable manner, and state and local agencies that are receiving those funds have to comply with Title VI, or they're going to lose or risk losing all of their federal funding. There's also the Alien Tort Claims Act. This has been around since almost the beginning of our country, and it was actually passed to provide justice for people who were basically attacked and looted by pirates. So it gives non-Americans, that's the aliens, the right to sue American companies or transnational companies that are headquartered in the US. So starting in the late 70s, early 1980s, environmental lawyers had high hopes about using the Alien Tort Claims Act to go after companies because a lot of the major polluters are headquartered in the US. Unfortunately, in 2004, there was a Supreme Court case, Sosa v. Alvarez-Machain, where the Supreme Court held that, yes, you can bring environmental claims under the Alien Tort Claims Act, but you've got to be allegedly violating some international norm that was accepted as an international norm 200 years ago. Obviously, a lot has changed in the past 200 years, so unfortunately, this 2004 Supreme Court case creates a very, very narrow class of international norms. And that's on top of a number of procedural hurdles related to suing under this particular act. There is also another fairly old statute, the Civil Rights Act of 1871. It gives individuals a private right of action if a person operating under the color of law deprives you of your federally protected rights. So basically, it allows individuals to sue their local and state governments for violating their constitutional rights. And we call these Section 1983 lawsuits, and we will talk about them more later in the course. So there are government actions that can be harmful, but government inaction, the lack of action, can be equally harmful. And looking back on the water crisis in Flint, Michigan, we can see that the local and state governments failed to act. Sometimes they failed to act deliberately. Many legal experts say that Flint is all about unequal protection and the state's failure to enforce the laws. Now, those laws themselves were not ideal, but the real problem was that they were not being properly enforced. And as you may remember from the General Motors versus FERC case, government inaction is very difficult to fight. So we discussed GM v. FERC in week 2 and week 6, and it's that pipeline case where GM sued to intervene and force FERC to take action. And the court held that if an agency decides not to act, the courts cannot step in and tell an agency to act. What this means is it can be really challenging to get an agency to enforce its own laws and regulations. Because if the agency won't cooperate and the courts feel they can't help, then it's really Congress or a change of presidential administration that can help, unless, of course, you're able to sue for actions that are unnecessarily or illegally withheld. So it's not that this has gone unlitigated. The Equal Protection Clause and the Civil Rights Act of 1964 actually are used quite a bit in environmental justice litigation. It's that unfortunately there were a string of cases in the 1980s, primarily that were based on the Civil Rights Act, that didn't advance past pretrial motions. And these suits were basically complaining about waste incinerator sites and other environmental hazards being consistently located in poor or minority communities. And these cases were not necessarily dismissed on their merits. They were dismissed because the facts were not sufficiently tied to government action, because a lot of these were about private companies that were not receiving federal funds. So there was this string of cases that went nowhere, but many environmental lawyers and environmentalists do think that it's still a good idea to focus on Title VI of the Civil Rights Act, for any type of a lawsuit that claims environmental inequality. Now again, Section 601 of the Civil Rights Act, Title VI, it prohibits discrimination based on race, color, national origin by any government agency that's receiving federal assistance. However, to win an environmental justice case relating to this, the plaintiff has to prove that the agency intended to discriminate. So this goes back to the issue of covert discrimination that we discussed a couple slides back. So keep in mind, 601, Section 601, it required that plaintiffs show intent to discriminate, not just disparate impact. Section 602 had not been litigated, so there was an idea that maybe for regulations rather than statutes, plaintiffs would only have to show disparate impact. Unfortunately, there was a Supreme Court case, Alexander v. Sandoval, that shut the door on that. There was also a follow-up case, Gonzaga, it escapes me at the moment, Gonzaga University v. Doe. It helps if I actually look at the screen. Neither of these were actually environmental justice cases. The Sandoval case was about an English-only policy for taking a state driver's license test. Gonzaga was about enforcing FERPA, the Family Education and Right to Privacy Act. But these cases stand for the principle that while states have to comply with certain federal laws, those laws don't necessarily create the right for people, us as individuals, to sue the states for non-enforcement. But, as I mentioned, the EPA regulations do recognize disparate impact. And so perhaps that will be a useful way of expanding the realm of environmental justice litigation and scoring some wins. Because if the impact or the focus has to be on discriminatory intent, that is going to be incredibly difficult to prove. So, one of the ultimate case studies in environmental injustice and poorly made decisions by a government would be the Flint water crisis. There is a professor at the University of Michigan who basically said, this is his quote, "What stands out about the Flint water crisis is the apparent indifference, the lack of concern that they might be harming people. And even after the harm was created and acknowledged and people were suffering, there still wasn't a sense of urgency to fix the problems." Now, as an aside, the Michigan governor's office was exempt from open records laws. So, had they been subject to open records laws like all other agencies within the state of Michigan, Flint probably still would have happened, but the reaction would have been far different and a lot speedier. So I thought that this cartoon on white and colored was really right on point for Flint's water crisis. And on the left there is tap water coming out of a Flint hospital and obviously looking disgusting. Now, the Flint River, for a long time, had sort of been an unofficial waste disposal site for treated and untreated refuse of all types, from local industry, raw sewage from the waste treatment plant, agricultural and urban runoff, toxins from landfills, things like that. In 2011, the city of Flint was bankrupt and fell under state control. So then Michigan Governor Rick Snyder appointed an emergency manager for Flint. And this was basically an unelected, political appointee. And the emergency manager was supposed to cut city costs. So in 2013, the emergency manager decided to end Flint's practice of piping treated water from Detroit and go with the cheaper alternative, which was just to pump water directly from the river, the Flint River. And that river water was known to be highly corrosive. But the emergency manager and other officials in Flint and the state of Michigan failed to treat it. And so basically, as that water made its way through the pipes, the lead was leaching out and into thousands of homes. So what we think of as the Flint water crisis, it started with that decision in 2013, that they were going to go away from treated water and go to the river. In 2014, they actually did. So they switched the drinking water supply from Detroit's system to the Flint River, and they did this just to save money. And they didn't test or treat the water in any type of adequate manner before they made this decision and before they switched over. And that lack of adequate testing and water treatment resulted in just a ton of major water quality and health issues for Flint residents, including that disgusting colored water that was flowing out of their faucets. The water smelled bad, it tasted bad, it made people's skin itch. All of these issues were ignored, chronically ignored. And when they weren't ignored, they were discounted by government officials. So the complaints were mounting in Flint. Hey, this is causing skin rashes, hair loss, all of this. It's been going on for 18 months, and nobody was doing anything. At the sort of end of, the crisis in 2014, the Michigan Civil Rights Commission, which was a state-established body, said that the poor government response to Flint was really the result of systemic racism. And again, that University of Michigan professor, he highlighted the lack of procedural due process. None of the Flint residents were given any type of meaningful voice into the decisions that were affecting them. They didn't get to vote on an emergency manager. They had no say in it. They were not aware about the switch for the drinking water. They had no say in that. And really, it was the imposition of the emergency manager that caused a lot of the problems. So once that water crisis got to be national news, there were test results showing really elevated lead levels in Flint, especially in children. And so local residents joined with a couple of special interest groups like the NRDC, and they petitioned the EPA to launch an emergency federal response. And the EPA did not, which really only spurred residents on. So this went through several years of litigation before the Flint lawsuit, which was brought by residents of Flint, Natural Resources Defense Council, ACLU, and Concerned Pastors for Social Action. They filed suit in January of 2016. They settled the lawsuit in March of 2017. So the settlement requires that the city of Flint and the state of Michigan, they've got to replace Flint's lead and galvanized steel service lines within 3 years. They've got to provide, appropriate clean water. They've got to provide education. They've got to do extensive tap water testing. And also the state has to pay $97 million to, do all of this work. The plaintiffs have had to go back to court twice in the summer of 2018 to enforce that settlement agreement. And the court just modified the settlement agreement in February of 2019. And the court in the settlement agreement and a lot of media pointed out, Flint, the population of Flint is 57% African American, and 42% of Flint citizens live below the federal poverty line. And when it mattered most, officials decided that they weren't going to bother to enforce the rules that were designed to keep these residents safe from all of these toxic hazards. It, certainly looks like the Michigan Department of Environmental Quality really bore the primary responsibility for the disaster. But across the board, government workers in the State Department of Health, Human Services, Governor's Office, County Health Department, federally at the EPA, they all fell short in their responsibilities. They just kind of had a systemic disregard for Flint's residents, and that's in part because this was a poor and minority city. We're going to talk about that more on the discussion boards this week. So the Flint water crisis has gotten much, much better, but is still sort of a depressing thing to think about. But it has, in part, brought us some new legal strategies for pursuing environmental justice. One of these strategies is to basically posit that the under-enforcement of laws is unequal protection in violation of the Equal Protection Clause. This stance, it requires a much more robust view of equal protection and its application to agency action. And again, remember GM versus FERC, government inaction is much harder to challenge. But now that we have had the situation in Flint, combined with the DOJ applying the stance to law enforcement agencies, it's very possible that we can also apply this to other agencies that have an impact on civil rights. And that would include environmental and emergency response agencies. There is also the public trust doctrine that was covered in the textbook reading for this week. It has been used in some states, California, Hawaii, to protect environmental and recreational interests. So in states where the public trust doctrine really has a lot of teeth, members of the public can sue to enjoin an action that would violate the public trust, such as filling in tide pools to build a condo or taking too much water from a navigable river. Now, there are other states that have tried to restrict or even block the public trust doctrine. And really, the public trust doctrine is all about special protection so that everybody in the country can benefit from navigating the waters, engaging in commerce, fishing, recreation, all of that. There are states that have tried to really restrict it. Idaho's legislature, as the book said, actually passed a law prohibiting courts from applying the public trust doctrine, particularly to water cases. And that actually might itself violate the public trust doctrine. So I'm really interested to see which of these legal strategies are going to be, is going to be the first to stick. Because I think particularly after Flint, there's a much greater understanding of the failures of our infrastructure and some poor decision-making, including cost cutting without looking at the impact on particularly poor and minority communities. We're kind of coming to a head on this in the US, and I think that we are going to finally get a break here and see some environmental justice litigation that moves forward in a really positive direction. Okay, that's it for this week. We do have a discussion this week. We're going to be talking about environmental justice in Flint and elsewhere. You also have your prospectus due by the end of the week. This is your prospectus that's going to describe your topic for your policy analysis paper. This doesn't need to be formal. I will have a Dropbox where you can upload a file. You can also simply email me. Do take a look at, it's set up as an assignment even though it's ungraded, but take a look at that assignment because it does tell you exactly what needs to be in your prospectus. Next week, spring break, woo! But then after that, week 11, we are going to start discussing a civil action, so please do be sure to finish it by the end of the month. All right, thanks so much for listening. Have a great week, and I'll see you on the discussion boards.